Welcome. Hi, my name is Susan Berke Fogel. I am the Director of Reproductive Health for the National Health Law Program, and I want to welcome you to the latest webinar from the ABA section of Civil Rights and Social Justice, brought to you by the Religious Freedom and Health Rights and Bioethics Committee. If you like our work, we really invite you to become a member of the section and collaborate with us on projects you want to develop to offer to our members and to the general public. For more than 5 decades, the section and its members have worked on hundreds of issues addressing a broad range of civil rights, civil liberties, and international human rights. Today, the section continues to promote policies affecting religious freedom, LGBT rights, gender equity, and other significant civil rights issues. We're really thrilled today to bring you this program. My co-panelists are Richard Katskee of Americans United for Separation of Church and State and Sara Hutchinson Ratcliffe from Catholics for Choice. We are going to be talking about the new federal rules protecting statutory conscience rights in healthcare and delegations of authority. So I'm going to get us started by giving some background and context for the new rules, and also tell you a little bit about the National Health Law Program. We are celebrating our 50th anniversary. We were founded in 1969, and we protect and advance the health rights of low-income and underserved individuals and families through litigation, advocacy, and education. We have offices in Los Angeles, Washington, D.C., and Carborough, North Carolina. So we're going to be talking about healthcare refusals, religious objections, often called conscience clauses, and there's other terminology. But just to set the stage, every person who enters a healthcare setting expects that the care they're going to receive is going to meet the medical standards of care. It's going to be evidence-based, patient-centered, and prevention-oriented. And usually in law and medicine, there are consequences for failing to meet these standards. Healthcare refusals or conscience clauses are literally legal protections that allow people to opt out of providing care that they would otherwise have a duty to provide. Healthcare refusals tend to fall in 2 different areas. There are the ability to refuse to provide care to others, and also the ability to refuse to either accept care for oneself or one's children. So for example, the ACA, there's an exemption for the requirement to have minimum essential coverage. There are laws that allow parents not to vaccinate their children or not to participate in what would otherwise be mandatory health screens. We're going to focus on the opting out for delivering care to others. And I also want to note that religious exemptions appear in many different parts of the law, so we're really going to be focused in this discussion. So first of all, what are the underlying statutes? I'm going to just mention 4 basic statutes on which these rules are based, and the rules themselves reference up to 25 statutes, so we're not going to get into all of them. The first, one of the most fundamental, is the Church Amendment. Church Amendment is actually named after Senator Frank Church, not the religious institution, and it was enacted in 1973, shortly after Roe v. Wade. Basically, Church Amendment says that federal or state funds cannot be predicated. There cannot be a condition of funding that requires individuals to perform or assist in abortion or sterilization, cannot require an institution to make their facilities available, and cannot require an institution to provide personnel for performance or assistance in abortion or sterilization. And also an individual cannot be required to, and these are really important words that keep coming up, perform or assist in any part of a health service. The second basic one is the Weldon Amendment. The Weldon Amendment is an appropriations rider, so it gets attached to appropriations in each session. It's since 2009. And that says the government cannot discriminate if a healthcare entity, and all this language is important, does not provide, pay for, provide coverage of, or refer for abortions. And Weldon is very specific to abortions. And a healthcare entity is defined as an individual physician or other healthcare professional, a hospital, a provider-sponsored organization, an HMO, an insurance plan, or any other kind of healthcare facility and organization or plan. The ACA also has a exemption that says that a health plan offered through the marketplace cannot discriminate against any individual healthcare provider or facility because of their unwillingness to provide, pay for, provide coverage of, or refer for abortions. Pretty much mirrors the language of the Weldon Amendment. I would also just flag that the Church Amendment also protects willing providers, but neither Weldon nor the ACA include that willing provider protection. And the last one is the Coates Amendment, which is about medical education, which says that a medical education program cannot be denied accreditation solely because it does not include teaching or referring for abortion. So let's talk about the regulations. The regulations have a history going back to 2008 when George W. Bush issued regulations at the very end of his term. They were very broad. And then in 2009, President Obama repealed those regulations, but kept the part of the Office for Civil Rights being an area where a place for people explicitly to file complaints when they feel they've been discriminated against. From 2009 to 2016, there were 10 complaints that were filed with the Office for Civil Rights. In 2017, there were 24 complaints, and we don't really have any good data for how many complaints have been filed since then. The Trump administration has taken several steps to really broaden healthcare refusals. First of all, there are new rules on the exemptions to who has to provide contraceptive coverage, and Sarah's going to talk about that a little bit. The Office for Civil Rights created a new division, the Conscience and Religious Freedom Division, that's headed by the Deputy Director of OCR. The mission and vision of OCR have been revised to elevate conscience to a level of other civil rights and also to emphasize enforcement. And then we have these new regulations. The regulations were scheduled to go into effect next Monday, actually, the 22nd, but due to extensive litigation, and Richard is going to talk about that, they now are not going into effect until November 22nd. So quickly, what do the regulations do? They fall into really three elements: who can refuse, what can they refuse to do, and compliance and enforcement. So who can refuse? And this is where the language of the statutes is really important and where these regulations actually broaden that language. The underlying statutes use words like individual, entity, healthcare entity, and specifically reference, as I've already said, individual providers, healthcare professionals, provider-sponsored organizations, insurance plans. The new rules, however, first of all, define individual as the words person in the law that now includes corporations, companies, associations, partnerships, joint stock companies, as well as individuals, and also includes states, public entities. The department itself is now covered by these rules, and also includes foreign governments and international organizations in some instances. And we're not really going to talk about the international implications, but there is a lot to talk about there. I'll give you an example. In 2016, a group of religiously affiliated employers filed an OCR complaint against the state of California that requires abortion coverage in health insurance programs. The OCR found that these employers were not healthcare entities under the definition of the law because they're employers, and therefore denied their complaint. Here, the new rules, even in the preamble, discuss the California case and have now say that even an employer who is not a healthcare entity or is still considered a healthcare entity for the purpose of the new rule. So broadly expanding who is obligated under these rules. They also reference federal funding. So for example, they give the example of an HIV/AIDS prevention organization that the department itself cannot refuse to fund an organization because it won't use a multi-sector or comprehensive approach to HIV/AIDS prevention, which we know generally includes condoms. Also redefines workforce. So workforce is basically everybody in a healthcare system, volunteers, trainees, sub-recipients, and the rules very specifically say workforce is, again, to be broadly defined. So what can they refuse to do? Again, remember the Church Amendment protects willing providers. Unfortunately, these rules do not protect willing providers. The basic language in all of these rules, statutes, is perform or assist in the performance of something to which the person objects. Common language, of course, would mean to, help with this. Webster gives an example of a surgeon helping in an operation, something that's rather direct. The Bush regs, which were repealed, had stretched that definition of perform or assist to include a reasonable connection to the service. And these regs take another step. And they say, I will quote this, to take an action that has a specific, reasonable, and articulable connection to furthering the procedure or the part of the healthcare program that to which the person has an objection. Some examples in the proposed rules are making arrangements for, which is not really defined. So we don't know, does that mean just scheduling? Does that mean, what does that mean? Preparing a room. It does give an example of scheduling and does not rule out that this could even include transportation. So could an ambulance driver refuse to transport somebody for a procedure to which the driver has an exemption? A lot of these things are left to be determined. And the what also includes what type of objection do they have? The underlying statutes generally say a religious or moral objection. The rules also expand that to say something to which they object for religious, moral, ethical, or other reasons. Other reasons are not defined. In the proposed rule, there was the example of a pro-choice person who chooses not to participate in an abortion, so therefore doesn't actually have a religious or moral objection to the abortion, but chooses in a particular circumstance. The last really important thing is referrals. So like, what's a referral? Generally, a referral is you give me information that with some specificity so I can get the service that I need. A referral under the rules includes pretty much any kind of information, websites, phone numbers, even directions, whether it's electronic, oral, or written. So someone does not have to hand you a piece of paper that has information on it, where the purpose or even the reasonably foreseeable outcome is to assist the person in getting something to which the referrer has an objection. I will point out that this is a little bit more narrow than the proposed rule, because the proposed rule only required a possible outcome. So at least it's a little bit more tailored. The rules also bring in Title VII on employment discrimination. Title VII, has a requirement for religious accommodation, but also has a hardship requirement to that exemption. The rule here allows an entity to ask an employee if they have an objection to performing, referring for, participating, but the inquiry, according to the rule, can only happen after the person is hired. It's very unclear Under what circumstances you can ask people if they have an objection to a service that is important to the employer. And there isn't any hardship exemption in those rules. And then the last thing is a real emphasis on notices, monitoring, and enforcement. Every recipient of federal funds has to certify compliance with the rules as a condition of funding. OCR has broad powers to investigate and to enforce the rule, including access to records. And while the proposed rule actually required posting a notice, the notice now is voluntary, but OCR says that whether or not you posted a notice might be taken into account when they are deciding whether or not you're complying with the rule. If an entity is found to be non-compliant, then they must report that to any federal funding agency for 3 years as part of the application for funding. So that's basically what the rule does. I'm going to turn it over to Sara now to talk a little bit about really what the implications of the rule are going to be.
Thanks, Susan. That was really helpful to have that broad explanation of sort of where we came from and how we got here and what the rule does. My name is Sara Hutchinson Ratcliffe. I am the Vice President of Catholics for Choice. For those who are not familiar, we are an international advocacy organization which represents the majority of Catholics across the world who disagree with the hierarchy of our church on issues related to sexual and reproductive health and rights. And we really work at the intersection of faith, women's health, reproductive choice, and religious liberty, both at the national level and in international debates around the world. We were founded in 1973 to serve as a voice of the 70 million Catholics in the United States and 1 billion around the world who disagree with our hierarchy and their agenda for public policy that legislates one particular religious view into public law. Our work really promotes the idea that the moral autonomy of each person is based on the foundational Catholic teaching that every individual has a conscience and the right and to follow that conscience where it might lead, and our call to respect others' rights to do the same. Our Catholic tradition really requires us to respect the conscience-based decisions and to advocate for the poor and marginalized to make their own decisions as well. It also respects religious pluralism and religious freedom. So as Susan described, the thing to think about when you're talking about either religious refusals or what this rule and the current administration calls conscience protection is both what is a conscience and what are folks refusing. So as Susan outlined, what this rule does is we want to look at who is allowed to refuse and then what are they allowed to refuse to do. In reality, this rule really expands the scope and the reach of religious exemptions, specifically under HHS programs and activities. We believe, and many of those who are working really to hold the administration accountable on this overreach, believe that HHS really should advance policies and regulations that promote principles of social justice, that protect moral autonomy for every individual in healthcare and human services, and really ensure that everyone's religious liberty is protected, not just those who agree with one particular view or who want to refuse to do things. And this is true not only in healthcare, although that's the most, I think, egregious examples and sort of the most obvious place where these ideas come in conflict, but also in public service provision. So soup kitchens, adoption agencies, and other social service agencies are a part of this, not just healthcare. As a faith-based organization, we have a really strong and deeply rooted conviction on the importance of protecting conscience and conscience-based decisions, particularly in healthcare. It's important that conscience be protected, certainly, especially when it's about the provision and access of healthcare. But conscience protections must include provider and patient alike. And as Susan mentioned, not just those providers who want to refuse to do things or who feel compelled to refuse to provide services or to be involved in service delivery, but also for those who wish to provide, which this rule does neither. The bottom line is that the personal beliefs of any provider should never impede the care that a patient is able to receive or the services that a beneficiary might access. Focusing exclusively on those who have objections, who wish to deny patients the care they seek based on their own personal beliefs, really constitutes what we call a refusal clause, rather than a protection clause. And by ignoring the protections of conscience-based decisions with providers who want to provide the full range of care or who want to provide a specific service, it really undermines the idea that the constitutional protection of conscience should go on both sides. And instead, what this rule really does, we believe, is constitute state-sponsored discrimination, because individual providers are allowed to discriminate against the patients in front of them based on their own personal beliefs, thereby imposing religious fiat, imposing their beliefs on someone else, rather than protecting the exercise of faith. Let's see. I think the other important thing to bring out is, as Susan mentioned, this new division and this rule affirmatively allow institutions like insurance companies, hospitals, healthcare centers, and almost any entity along the spectrum of patient care to use a false claim of conscience and or the individual personal beliefs of the leadership of any of those entities to deny people the care they need. Institutions, entities don't have consciences to be protected. Conscience is an individual idea. Neither the freedom of conscience nor the freedom of religion based in U.S. law should be misconstrued as extending these protections to institutions. It really ignores the moral agency of the individuals who seek programs and services under HHS. From a Catholic perspective and from a faith-based organization, granting entire institutions this right of conscience that should be left to individuals is really an affront to our ideals of conscience, workers' rights, social justice, and what true religious freedom means. To expand the definition of entities and suggest that those entities have a religious or moral conscience right, and that includes states, government organizations, Medicare, Medicaid, other public insurance plans, really suggests it allows those who have objections to trump the beliefs of the very real people that are meant to be cared for. And the proper role of government, in our view, is to protect the freedom of conscience for everyone, every individual, not for large entities which don't really have them. The other important point, I think, is that protecting taxpayer dollars from being funneled into institutions that refuse to do the things for which they are being contracted to do, like provide comprehensive care under Title X, for example, like refusing to provide an abortion for a woman in an acute medical crisis, or firing an employee after learning that they have a same-sex partner, overriding patient preferences in end-of-life care because you don't personally believe in medical aid in dying. There's a number of instances where the conflict of what a patient needs and what service that should be delivered would be impeded by these protections that have been instituted. This is not really about protecting conscience. This is about allowing the federal government to be in the business of interfering with the religious and moral decision-making of patients and some providers at the behest of those who want to refuse. And in fact, the beliefs, the moral convictions, the rights of conscience for individuals who are seeking care or seeking services through HHS programs is not mentioned one time in the 144-page rule. The beliefs of patients, the protection of conscience of patients is not even mentioned. So clearly, this is not where the balance of that relationship is not something that HHS considered in promulgating this rule. The other point I want to mention is that faith-based providers play a substantial role in the provision of health and human services across the United States. They often serve as pillars of the community. They're trusted to provide necessary care and essential services, often to very underserved groups and individuals. And faith-based groups provide services to people of all backgrounds that are in need, whether they are adherents to the same faith tradition or not. They have extensive networks and infrastructures and often can play a pivotal role in serving as a gateway to patient care as well as other services and well-being. However, at the same time, faith-based providers, entities, use very conservative interpretations of some religious teachings to deny access to these critical services, including family planning services, abortion, gender-affirming care, and much HIV and AIDS prevention services. This has obvious implications for women and girls, but for people, really LGBTQI people, as well as folks in underserved areas who might not have other choices. The impact of this rule is a really important thing to focus on. The faith-based providers or providers who choose to avail themselves of the protections that this rule provides really also use religious interpretation or moral interpretation, or really any interpretation of why they don't want to provide a service, to discriminate against those populations that really need care and support the most. These include, as I mentioned, LGBTQ individuals, unaccompanied minors in need of reproductive health care, immigrants coming across the border, refugees seeking shelter and sanctuary, all of these really vulnerable populations where someone else's beliefs are going to be imposed upon them and refusing them care that they may not even realize is available. Denying individuals these services based on religious objections really undermines the very purpose that taxpayer-funded services and programs are meant to help those in need. HHS grantees and contractors should not be allowed to discriminate against those who serve or who employ, who don't act in accordance with one particular set of religious beliefs. That might mean an employee who doesn't attend religious services. So that also is an area where, or a beneficiary who doesn't attend religious services regularly. Same-sex marriage, the folks with same-sex spouse, or someone who gets divorced. Also someone perhaps refusing care to a pregnant woman who is unmarried. These are kinds of things where someone might have a moral objection and then is interfering with the necessity for care and services that those folks would get. The last point I want to cover is that the reality is that the Trump administration and this particular set of rules and regs has really turned on its head the idea of who wants these protections. The reality is the vast majority of people of faith, Catholic and others, do not agree with religious refusals, do not agree with protections for some to take discriminatory practices against others because they believe differently. For example, 7 in 10 United States Catholic voters believe that companies and institutions should not be allowed to use religious beliefs as a reason to deny services to employees or customers. 90% of Catholics disapprove of a company firing an unmarried employee who's pregnant because the owner believes that that's wrong or a sin. 86% also disapprove of a counselor refusing to counsel a gay student based on counselor's beliefs. Americans really across the spectrum of faith reject the idea, and they overwhelmingly disagree with these kinds of refusals in a number of different areas. Almost 9 in 10 Americans of all faiths say that a scenario where a doctor refuses to tell a woman about an abortion, refuses to give a referral or even explain her options because of his personal beliefs is wrong. 62% reject the idea of allowing a Catholic hospital to refuse to perform even a medically necessary abortion based on that Catholic tradition. Nearly 7 in 10 Americans reject the idea of that doctor refusing because of his own an abortion referral because of his own beliefs. And finally, over 3/4 of the American public of all faiths think that a pharmacy should not be allowed to decline to fill a prescription for birth control because it goes against the owner's religious beliefs. We saw in a number of case law that I think Richard is probably going to mention in Hobby Lobby and Zubik that the Obama administration tried to create an accommodation for those who do not believe in certain forms of birth control as a religious belief. However, what wound up happening is that the plaintiff tried to claim that that meant that they didn't have to even provide referrals or access to it by refusing to provide even an alternative to folks getting the coverage for, in that case, birth control. It really denied the right of most of the vulnerable populations that need these services from getting any kind of care at all, or severely burdened the access to care, both birth control and abortion, among other things. So not only is this rule against what most people believe who are faithful and whether and how to do it, it actually does the opposite of protecting conscience as it purports to do. It simply protects the conscience of those who believe a very narrow set of beliefs. We think this is wrong, and we join with our partners like Americans United and others who are challenging it in litigation.
Thanks, Sarah and Susan. There are currently 8 cases challenging the denial of care rule. I should say the Department of Health and Human Services, HHS, calls this a conscience rule, but there are lots of things that the government describes that way, and so most everybody else has taken to using the terminology of a denial of care rule to make clear what we're talking about. I'm the legal director at Americans United for Separation of Church and State. Americans United was founded in 1947 to protect religious freedom by safeguarding the constitutional protections for separation of religion and government, which are what allow all of us to believe or not, to worship or not, according to the dictates of our conscience. Now, what I'm going to do is to start by quickly listing each of the cases, because that will add a little bit of color to what Sarah and Susan have each talked about who is affected by the rule. And then I'm going to kind of walk through some of the legal claims. Since this is a legal audience, you get to do that, and so I will do my best. Now, first of all, there are 3 cases that have been filed in the U.S. District Court for the Northern District of California. One of those is ours at Americans United. The plaintiffs in our case are the County of Santa Clara, California, a whole host of wonderful nonprofit medical centers and clinics across the country that principally serve the LGBT community or provide reproductive health services, professional associations for LGBT physicians and psychiatrists, a medical students association that protects reproductive rights, and a number of individual doctors. I have to give a quick hat tip to my wonderful co-counsel from the County of Santa Clara, Lambda Legal, Center for Reproductive Rights, and Mayor Brown LLP. Also in the Northern District of California, the state of California has filed suit, and in the other case there, so have the City and County of San Francisco. These are 3 separate lawsuits, though the court is thus far looking at them together. The other case in which we at Americans United are counsel is in the District of Maryland on behalf of the Mayor and City Council of Baltimore, in other words, Baltimore City. Hat tip here to my great co-counsel at the Baltimore City Law Department and Sussman Godfrey. There are then 3 cases in the Southern District of New York which have been formally consolidated. One was brought by New York and 19 other states, plus New York City, Chicago, and Cook County, Illinois. One that was brought by Planned Parenthood, And the third, the plaintiffs are a nonprofit public health provider and an association that promotes healthcare for family planning. In those cases, there are also intervener defendants, in other words, on the side of the rule and the government in those suits, the Christian Medical and Dental Association and an individual provider. Last but not least, in the Eastern District of Washington, the state of Washington has also sued over the rule. Now, as Susan mentioned, the rule was originally set to take effect on July 22nd, which is this coming Monday. And so the plaintiffs in 7 of the suits filed motions for preliminary injunctions. In the face of all of that, the government agreed to delay the effective date of the rule until November 22nd, as Susan said. And because of that, the preliminary injunction motions are all being held in abeyance in case they end up being needed later. For any non-lawyers, a preliminary injunction motion is where you ask the court to stop the rule from being put into effect until while the case is being litigated and the court has an opportunity to decide the case. What's going on now is that the cases all have schedules for cross motions for summary judgment. In other words, to decide the cases on the merits, ideally before that November 22nd effective date. That brings me to the legal claims, and with so many different suits and categories of plaintiffs, there are, as you can imagine, lots of separate legal claims being made. So I just want to hit some of the highlights. First of all, there's a whole host of claims that the rule violates substantive provisions of the Administrative Procedure Act, which is the law, a federal law that specifies how agencies have to act when they're making rules and regulations. It's kind of an issue spotter for you admin law fans out there, so sorry about that, or enjoy it as you please. The biggest claims there are these. First of all, there are claims that the rule exceeds HHS, Department of Health and Human Services, statutory authority. In other words, that Congress didn't delegate to HHS the authority to pass this rule and to enforce it, so HHS, the agency, can't do that. In that regard, Susan talked about a whole host of federal statutes that the rule invokes and purports to implement. But as she also explained, and as the plaintiffs in the various lawsuits explain in their claims, those statutes provide a narrow, well-defined set of protections for a particular class of medical personnel with respect to a small set of procedures. We're basically talking about the people who actually might perform abortions or sterilization. What the suits explain is that, and as Susan talked about also, is that the rule covers every kind of health service, not just those, and it applies not just to the people who are performing the procedures, but to the people with only even the most tangential connections to them. The scheduler who answers the phone, the clerk who takes your insurance card at the ER, the janitor who restocks the operating rooms. Not to mention the folks whom we count on for life-saving care in emergencies, like the folks who drive the ambulance. There are also Administrative Procedure Act claims that the rule contradicts a number of federal statutes that protect patients against discrimination, such as its sections 1554 and 1557 of the Affordable Care Act, for instance, or that conflict with statutes that ensure that patients receive emergency treatment when they need it and on a non-discriminatory basis. An example of that is the Emergency Medical Treatment and Labor Act, which basically says if you're wheeled into the OR, they have to treat you at least to stabilize your condition and make sure that you're safe. They can't just refuse to treat you or ship you off to someplace else across town until it's medically safe to do so. So there are claims that that this rule requires healthcare providers to do things or to allow things that would violate those laws. There are also Administrative Procedure Act claims that the rule is arbitrary and capricious, those of course being the statutory terms. Depending on how you count, there were between 74,000 and 250,000 public comments on the proposed rule. The suits allege that the final rule doesn't generally consider those and doesn't fix or respond to or even speak to a bunch of serious problems that those comments raise. And among other things, that HHS, the agency, ignored the science that was presented to it in passing the rule. Also, HHS or the government is supposed to do a cost-benefit analysis for the rule or for all regulations. The suits allege that that the agency ignored the costs and harms to patients, about which Sara talked quite a bit, and especially patients in vulnerable populations, and that it ignored the risks and harms to the public health generally. Now, what the government says in the final rules preamble is this, and I'll quote, "It is appropriate to finalize this rule even though the department," that's the agency, "and commenters do not have data capable of quantifying all of its effects on the availability of care." Sorry for stumbling over that. And HHS then goes on to say that religious objections, and I'll quote here again, "are worth protecting even if they impact overall or individual access to a particular service, such as abortion." In other words, we know that patients are going to be denied care as a result of the rule, and that's okay. We're requiring this anyway. That's what the agency has said, and that's one of the things that is being objected to in the suit. Finally, under the Administrative Procedure Act, the agency justifies the rules by saying that it will encourage more entities to provide health care because they won't have to worry if they have religious objections to what they might be forced to do, and that it will somehow then enhance patient care. The lawsuits point out that the agency provides no explanation or evidence for any of that. And frankly, it's kind of hard to see how allowing healthcare workers to say, "We won't treat your kind," result in more or better healthcare services to the public. So the claims are that the rule is arbitrary, capricious, and contrary to the law, is again the technical terms. And then there are also a bunch of constitutional claims. A lot of what Sara spoke to relate to claims under the Establishment Clause of the First Amendment of the Constitution, which I believe all the suits make. The Establishment Clause prohibits government from imposing some people's religious beliefs on others. And for these purposes, that principally means that the government can't grant healthcare employees religious exemptions from laws or hospital policies when doing that would impose costs or harms on patients or on the hospitals themselves. The idea is that if the government shifts the costs of accommodating my religion onto you, then you're paying for my religious exercise, and that's the government preferring my religion to yours or to your other rights and interests, and in this case, your health and safety. There are claims brought by the state and local government plaintiffs under the spending clause of the Constitution. The spending clause allows the federal government to tie federal funding to federal requirements. If you want to take government money, you have to follow certain rules. And it's supposed to give the states a choice. If you want the money, you do this, and if you don't want the money, that's just fine. Don't do it. The claims are the government isn't supposed to be able to use such a massive threat of denial of federal funds as what's sometimes called in the cases a gun to the head of the states, leaving them no choice but to comply. The claim here, the spending clause claim here, is generally that the rules threat to deny Medicare and Medicaid reimbursements to hospitals and clinics and doctors, and to claw back all the federal funds provided means that states and local governments simply don't have a choice but to remake their public health programs in the way that HHS wants. Harms to the patients be damned. This is a type of claim that the Supreme Court, in an opinion by Chief Justice Roberts in 2012, recognized with respect to the Affordable Care Act. The idea is that unduly, call it expansive and coercive requirements tied to federal funding can exceed Congress's authority. And because Congress can't use its spending power that way, neither certainly can a federal agency. Relatedly, some of the state and local government plaintiffs have made related separation of powers claims. The idea is here that this spending power is vested in Congress, not in the executive branch, not in a federal agency. So when HHS imposes these draconian penalties, it usurps Congress's authority to decide how its own funding power is exercised. Finally, The cases have a number of other constitutional claims. These, to speak generally, come under the Due Process Clause, the Free Speech Clause, the Equal Protection Clause, and these are, for the most part, asserted by the healthcare institutions, the medical associations, and the individual physicians. And I'll just give you a couple of examples. For example, there's a claim that the rule threatens the operation of clinics that provide reproductive health services or services geared toward LGBT populations. So it unconstitutionally burdens fundamental rights to abortion and other reproductive health services. It chills patients' disclosure of sexual orientation, gender identity, reproductive health history, and which interferes with receiving care. And it encourages discrimination based on the identities of patients and the services that they seek, violating them equal treatment under the law. Let me stop there, and perhaps we can step back and talk more generally about who's affected by the rule, what the asserted harms are, or possibly if there are questions.
I don't see any questions in the question box. So perhaps I'll ask my co-panelists if you have any closing comments, and we'll give everybody 14 minutes back.
Sarah, do you want to go ahead?
Sure. I think the important point for folks to realize is whether it's the litigation that's challenging the rule or whether it's the literally hundreds of thousands of comments that were generated in the lead up to the final rule. The point is that the federal government is not listening to those they represent in promulgating this regulation that doesn't serve the public good. People of faith, people who seek healthcare don't agree with the idea that they're going to change how conscience are protected, nor how people are able to access care without the imposition of someone else's faith or belief. So we at Catholics for Choice, as well as our partners in the faith community, certainly will continue to stand in whatever way we can to fight against the real harms that we believe are going to come if this rule is allowed to stand.
So since we've talked, we've mentioned or invoked all of those comments, maybe I'll take a minute to just say some of the kinds of entities and individuals that have commented on the proposed rule and sort of speak generally about some of the problems that they cited to be aware of what the rule does. And as commenters on the rule and folks who have voiced objections, there were, of course, the state and local governments, hospitals and clinics across the country, the American Medical Association, the American Psychiatric Association, the American Association of Medical Colleges, lots of advocates for patients' rights and the public health community generally, many other categories of entities also. They have overlapping concerns, as you might guess, but let me see if I can break it down a little bit. The hospitals, clinics, medical associations, advocates for patients, they talked extensively about the problems that the rule can create for medical facilities and doctors to ensure that patients are getting the care that they need and that medical services are delivered efficiently, effectively, and equitably when their employees can simply decline to do their jobs, help people because they have a religious objection based on a patient's identity or the care being sought. The governmental entities, the states, municipalities, the public health departments, they expressed concerns about, among other things, how the rule will undermine the provision of medical care and critical public health programs in their communities, and especially for poor and at-risk populations, where you have to work really hard to develop trust in those populations to have folks come and seek care, and that can be destroyed in an instant when somebody goes to seek care and is turned away because I don't deal with you or I don't like what you're doing. The medical schools and the professional associations worry about how they can train physicians adequately to meet their professional obligations, and oaths as doctors when the students can refuse to work with patients or learn to do the procedures that they object to. Hospitals and clinics worry about how they can deal even with the basics of staffing when they're not allowed to ask when they go to hire somebody, hey, are you willing to do the tasks that the job requires? The governmental entities worry about how the rule conflicts with and undermines state consumer protection and patient protection statutes, anti-discrimination laws, malpractice laws, and I think a whole host of broad range of entities and individuals have expressed concerns about the difficulty, expense, and risk of punishment under the rule, meaning that they're going to have to start cutting services, especially safety net programs and healthcare for the poorest and most vulnerable patients, because the risk of the punishment under the rule is so great that you have to save some of your programs at the expense of others, and sometimes the very most important ones. In other words, there's a huge amount at stake here, and lots of folks are affected and worried.
We have a couple of questions. The first is, what are the implications of these rules during critical moments, like during natural disasters? I think it's really important to point out there are no exceptions in these rules. There's no exception for emergencies. There's no exception for natural disasters. You know, it's interesting, in terms of federal funding for abortion, there are exceptions for pregnancies due to rape or incest or to save the life of the mother. No such exemptions exist in these rules. So the answer to implications are, it's very, very problematic. So I don't know if I want to make sure we answer the other questions. The other thing, this is for Richard, is where do you see the litigation going?
So I can answer that sort of procedurally and substantively as best I can, trying to be quick about it. As I think I said before, the courts in all the cases now have set schedules with an eye to summary judgment, deciding the cases on the merits by November 22nd. And if we get close to those dates, the preliminary injunction motions, the things that would delay the rule further pending the litigation, would kind of kick back in, and the courts would look at those. So we anticipate having a decision, though, before the rules go into effect, and then certainly appeals from those decisions from whatever side, meaning that it can be a somewhat long process, but that we have some indications in the first instance. I will say that there haven't been any substantive decisions yet, so we don't have any signifiers about where the courts are, except that it really mattered to at least some of the judges that when the government wanted to delay the preliminary injunction proceedings, the courts were not willing to do that until the government delayed putting the rule in place, because of the showings that the plaintiffs made about all the harms to all the folks who would be affected by it. So there's a real impetus to try to deal with things quickly.
Thank you. So we have another question, is there anything we've learned from this process that folks can use as we post comments in regard to the proposed changes to Section 1557, which is the anti-discrimination provisions of the ACA? I will add how important it is for comments to have real life experiences and evidence of the harm. It is, we realize that, you know, there are a lot of Me Too comments, and that's helpful, but what's important is for individuals and providers and organizations to document the real harm for these of these rules. And I don't know, Richard or Sarah, do you want to add anything to that?
Yeah, I absolutely agree. It's important that individuals express their own perspective and experience with these kinds of the harms that might be caused, or the kinds of situations where allowing this kind of discriminatory practice might affect them. I also think that, as Richard sort of alluded to, when and if there's a challenge and litigation comes from a rule that we think is wrong, it is critical that there be a breadth of perspective in the comments that the litigators can then call upon. So I think that it doesn't necessarily mean to be that only people with expertise can make comments, that the more people that talk about their own experiences, even from a layperson, non-attorney, non-healthcare provider, the more comments that people can do, the better armed we can be to challenge a bad rule.
I think that's right. The government is required to respond to comments. It's supposed to take them into account. When it does, one hopes that it does that seriously, which should change what these rules are. And when the government doesn't, that becomes a basis for the legal challenges.
We have another question. How these regulations will disproportionately influence certain communities, women, LGBTQ people. Do you anticipate the implication will be felt drastically between low and high income communities? I mean, I just have to say that I think to some extent the answer to that is obvious. Rich people can go anywhere they want and get anything they need. You know, we know that in terms of access to abortion services, most of the country is underserved. Women with means can get on a plane, take time off from work, afford childcare to care for their children. Low-income people cannot. It's the same thing for gender-affirming care. If you live in an area where all of the hospitals, for example, follow the ethical and religious directives for Catholic healthcare, and you can't get gender-affirming care, if you have money, you can go to an urban center. If you don't, if these rules are allowed to discriminate against people, then you won't have access to that care. Anyone want to add something to that?
I want to talk a little bit more about the public health consequences generally, which relates directly to poorer communities, as well as communities of color, LGBT communities. Folks, what I've learned from my clients are that that it can, and particularly the public health programs, it takes enormous work, time, investment of effort and money and everything else to build trust in communities so that folks will come to you to seek health care. This matters enormously when you're dealing with potential epidemics, that folks have to come and know that they're not going to be judged, shunned, turned away because they're poor, or because they're people of color, or because they're gay, or because they're trans, and all of that can be lost, can be destroyed quite quickly when a patient is turned away or ill-used by a healthcare worker. And when that happens, it's not just the individual who suffers. It's also all the folks in the communities that depend on proper health care preventing the spread of communicable disease.
Another question about, do the laws provide a definition for abortion? The answer is no. And we have well-documented cases of women who are miscarrying, who are either turned away, or their miscarriages are not properly treated because there's still a fetal heartbeat. And so we don't actually, other than the medical associations that have a definition, there's no definition in the law. And so I think this is a really important question in which to finish, which is I'm sorry we can't answer all these questions, but by the way, we will be happy to respond by email. What do we do about this as citizens, nurses, and public health professionals? Where is our voice? Sarah, you want to start?
Yeah, I think this is one of the most important aspects of this process. It is important that citizens, certainly, but also especially people who are affected in their vocation by these regulations and how their colleagues or the entities that they work for might utilize the exemptions that are provided in this rule. So I think it's important as public health professionals to make sure that you understand what and how the entity that you work for, how they see these regulations, if they have a policy of refusal. Also to make sure that you have the right to tell your patients what will and will not be provided. And if it is the case that you're working in an institution that refuses or wants to have a policy of refusal for any given service, that you consider protesting that through the employee channels that may be available to you.
So one of the things that fits right with what Sarah just said, one of the things that I have seen in my practice and in dealing with this rule and who it affects is that most healthcare professionals, most healthcare institutions want to be able to treat patients, want to be able to do it fairly, efficiently, really do it right. They have ethical obligations. They went into this field for a reason. It wasn't about making money. It was about helping people. And they worry greatly that this rule sets up a system that will interfere with their ability to do that to the detriment of patients. And so, as Sarah said, speaking up is incredibly important. Speaking up on behalf of your patients is incredibly important.
And I want to echo that and underscore to remind us that a healthcare refusal is permission not to provide the medical standard of care to patients. We're going to wrap this up. I want to thank my fellow participants. I also want to thank the ABA section on civil rights and social justice for hosting this webinar. We will share a recording of the program to everyone who is registered, so you can also share it with your networks. Please feel free to leave us feedback and ask more questions. We'll be happy to answer them. And also think about joining the section or even making a donation to the section so that we can continue to put on webinars like this and continue the activities of the section. So thank you to the ABA and the section, and thank you to all of you for attending and participating in this webinar.
Thank you.
Thanks so much.